Hi.
Hi.
How you doing?
Very well, thank you. It is. It's a very important one too. Okay, good afternoon everyone and welcome back. I know most of you, those of you who are not here, obviously probably have not done the test yet. Now for those of you who've done the test, you should forget about it and concentrate and move on. Now let's look at this topic. Topic 5 would come out in the final exams, so it may be examinable, and it's one area that we need to focus on. Now you'll be introduced to two concepts. One in relation to contracts, or how does a company enter into a contract, and the other we look at corporate liability. Now the part that is highly examinable is the part where company enters into a contract. So this is the part that you have to concentrate on. You may get a short answer question which is worth 10 marks in the final exams if you're able to answer this question. Right? So let's look at what we are supposed to achieve by end of this lectures. There are two things that you are supposed to achieve. First, you have to understand how a company enters into a contract, and the next you have to understand what is meant by defective contracts and what are the rights of outsiders in relation to defective contracts. Now this is the learning outcome that we have to achieve by the end of today's lecture. Right? Now let's look at the first part. Before we carry on, can I just ask you a question? How do you enter into a contract? Okay, so you go there and you negotiate with the person and you sign a contract. Do you use anyone else on your behalf to sign a contract? No? Agents? You could. If you had a house and you got an agent to actually try to market your house, now that agent, you would have authorized that agent to act on your behalf. Would you not? Say if you put your house for sale and you know you're not very savvy in selling your property, you want someone who's able to sell it for you. So what will you tell your agent? Sell this house for me and this is the price I would like, but you have got some leeway in bargaining, so between this price to this price you can sell off my property. So you've given the agent the power to do so. Now the agent will enter into a contract on your behalf, and when you sell the property, he has created a relationship between yourself and the third party who's purchased the property. Right? Now as an individual, you can personally go and sign the contract, or you can get someone else to sign the contract for you. Now, going back to a company, we have already said that the company is a legal person similar to you and I. All right? Now, how does a company enter into a contract? Just like us, it's either directly or indirectly. When we talk about directly, it is where the company itself signs the contract. Now, you would think, yeah, the company doesn't have hands, legs, and brains. How is it going to do that? All right? There are provisions of law that we will look at which talks about how a company can enter into a contractual obligation. So when we talk about contractual obligation being entered into, we look at directly by the company and indirectly by the use of agents. All right? So you have to remember there's two ways that the company can enter into a contract. One is directly and the other is indirectly. Now let's look at how the company enters into the contract directly. Right? Now under section 127, all right? Now in relation to the slides there, you can see section 126. I would like you to amend that to section 127 because we are talking about company entering into a contract directly. All right? Now when they're entering directly, there's two ways of how the company can do it. All right? One, the company may adopt a common seal. I've showed the common seal before because someone gave me a brilliant idea to show it on Google Image, so you know how a common seal looks like. To adopt a common seal is optional in Australia, section 123. It's easy to remember, section 123. As easy as 123. All right? Now, you can adopt common seal. If you do not adopt the common seal, then there is a different procedure. All right? Now, what you have to understand is that before a company enters into a contract, the company must have been authorized to enter into the contract. So the first thing that you need to have is a board resolution authorizing the company to enter into the contract. So you have a board of directors resolution which authorizes the company to enter into a contract, and a second resolution authorizing the peoples who can sign the contract. So first, you have the authority given to the company to enter into the contract. Next, we look at what are the procedures. If you have adopted the common seal, then you would be having two persons, i.e. two directors, witnessing the affixation of the common seal on the contract. Either it's two directors or one director and a company secretary. Now, if the company does not adopt the common seal, then it will be two directors signing the contract or one company secretary and one director signing the contract. This is provided for under section 127 sub 1 A and sub 1B. And then with a common seal would be section 127 sub 2. Okay? Now you're looking at indirectly, we're looking at applying the agency principle. Now, if the company is not going to enter into the contract by itself, it can actually appoint someone else to enter the contract. And here you can have managing directors acting on behalf of the company, or someone who's been hired by the company to act on behalf of them. Now, this is governed by section 126. So 126 talks about handling of entering of contracts via the use of an agent. 127 talks about entering into a contract via the company by itself, where they've passed the board's resolution and they've complied with the procedures that they have to comply with. Either they have the common seal, or without the common seal, they have two directors and one director or a company secretary signing the document. Are we good? Silence means acceptance. Okay. So again, we look at the contracting directly. Please change the 126 there to 127. Okay, that's a minor correction. Right. So here, again, as I explained to you, there's two steps there is for a company to enter into the contract directly. First, they pass a resolution authorizing the company to enter into the transaction. They pass another board resolution authorizing those peoples who can sign on behalf of the company in the contract. Once they've done that, then we look at the next procedure under section 127, where it says if the company adopts the common seal, then the document, when the common seal is being affixed, it would be witnessed by two directors or one director and a company secretary. Where the company has not adopted the common seal, section 127 sub 1 tells us that they have two directors executing the document or one director and one company secretary executing the document. So that's pretty straightforward. Okay? You shouldn't have any issues with regards to that. Now, when we talk about, so if I asked you the requirements to actually, for a company to enter into a transaction, your answer would be? There's two requirements. First, transaction must be authorized. First, transaction must be authorized by passing of the resolutions. Next, we follow the procedure under section 127. If the company adopts the common seal, then the affixation of the common seal will be witnessed by two directors or one director and a company secretary. If the company does not adopt the common seal, then we will have two directors executing the document or one director and one company secretary executing the document. So it's very straightforward. If you have a question like this in the exams, you'd say 2 requirements need to be satisfied. First, we need to see whether or not the board of directors have approved this transaction. Next, we have to see whether this company has adopted the common seal or otherwise, and these are the procedures that they have to follow. All right? Pretty straightforward. All right. Next, we are looking at contracting through agents. Now, when we talk about the agency principle, there are 3 parties that we are actually considering. The parties are the principal, the agent, and the third party. All right? So these are the 3 parties we are looking at: the principal, the agent, and the third party. Now, I gave you an example earlier just now. I talked about you putting your house on sale, and you have actually got an agent to act on your behalf. So who is the principal in this situation? You become the principal. You are the principal, and you've got the agent, and any purchaser who comes into to purchase your property will be considered as the third party. So you have got an agency created here. You have a relationship, the principal has a relationship with the agent, and the agent enters into a relationship with a third party to place or to create the relationship between the principal and the third party. Now, most of the problems will come or will arise when the principal says the agent is not authorized to act on my behalf in this respect. So that's when the issue will arise, because the third party will say to the principal, you are bound, you must sell the property. Say, for an instance, I tell the agent, I appoint an agent, I say, I want to sell my house between the range of 150,000 to 160,000. Now, the agent goes and negotiates with the third party to sell the property for 90,000. Okay. Now, the question is, am I bound by that agreement that the agent has struck on my behalf? Am I bound?
Yes.
Why?
Because you authorized him to do it.
Okay, what was my authority given? What was the authority that I gave him? Very good, actual, but what is the amount? So I gave him actual authority, express actual authority, for the range of 100,000 to 150. Now, he has negotiated a contract which is worth $90,000. Has he followed, or is he within the authority given? So am I bound to the third party? All right? So in this case, the third party will have an action against the agent because he has acted beyond the authority that has been given. Now, if we replace these parties again with the company being the principal and the agent being any of the employees or officers of the company, and a third party dealing with this agent to have a relationship with the company, the question would be, would the company be bound by it? And when we are trying to analyze this, we'll look at the type of authority that has been given by the principal to the agent. So we'll analyze that in a short bit. All right? Now there's actually 2 types of authority. One is actual, the other is ostensible or apparent authority. When we talk about actual authority, we are talking about actual express and actual implied. So when you look at actual authority, it can be expressed or it can be implied. Now, apparent, what does that English word apparent mean? Sorry? I can't hear you. Seems like. Okay, seems like. All right, sounds fair. Seems like what to whom? Oh, really? That's good to know. Yes.
Basically, it's officially or expressed. You don't actually have authority, but it looks like you do.
Okay. Now, let me ask you a question. How sure are you that I am hired by Curtin? My ID tells you that I'm hired by Curtin? My name is on the Oasis, so I must be hired by Curtin. But did Curtin tell you that? It is apparent to you from looking at the situation, it is apparent to you that I have been hired by Curtin. But you have not had looked at my employment agreement. You have not seen anything related to that to prove that I have been hired by Curtin. By the fact that I come here to deliver the lectures, you now assume that I have the power. So it is apparent to you from the presentations that's being made that I have the authority to be here. Now, who is the principal? Is the principal making the representation, or am I making the representation? Am I? Do I own Oasis? No. Who owns Oasis? Curtin. Do I own this card? This is Curtin's property. So that's Curtin there. So who's making the representation? Who's holding out? Is it Curtin or is it me? Curtin is holding out. Does Curtin have the power to hold me out? Does it have power to issue this card? Yes. Does it have power to put my name on Oasis? Yes. So the principal has power. And have you relied on the representation? Yes, you have. So that's apparent authority. Simple. All right? So we have looked at apparent authority. Now let's look at actual authority. Actual authority is very easy. If you expressly say it, or by conduct you make it sound that that person has authority, that's easily established. Now what's the challenge is implied or actual implied authority. Here it's not expressly stated, but it is implied. Now let's assume you have already passed off this unit and got employed as a, say, a general manager of a big company. All right? Now you're a general manager and you have got your contract. Your contract of employment will be just a few pages. They're not going to give you this long pages, this thick document for you to read. Otherwise, it'll take you a year before you sign the contract. All right? So now you have got a few pages and it says, as a general manager, you run this company and you have to do whatever that's related to the administration of the company. Now one day you decide that you want to hire a cleaner. All right? Now you want to hire a cleaner to come and clean the premises, obviously. Now, but your contract does not state that you can hire a cleaner. Now you are in a predicament. What do? Do you think you have the power to hire a cleaner? You're a general manager. Why? What makes you say that? It's implied in the position, all right? The general manager has got some powers which is customary to his position. So in his position, he's able to hire some people. So this is his customary duties that is implied in the position. And you do not have to detail down what are the things he can do. But however, if his contract says he can't hire people, then obviously he can't. All right? But where there is no conflict and he is the general manager, then he has the customary duties in relation to his position. So it's implied. You don't have to have it expressly stated. Now similarly, a managing director has powers. As a managing director, can you enter into a contract? Say, let's give a value to the contract. Assuming the value of the contract is $9 million. Is it implied in his powers that he can enter into a contract worth $9 million? Yes. As a managing director? You reckon? Too much? So if I change that figure to, say, $10,000, that's reasonable. That's okay.
But he's the CEO of a company. Doesn't he, like, he's the biggest boss, the only one who can stop him is the board of directors, right?
The case law, there are case laws which suggest that you can't do that. The amount must be within reasonable means. 9 million is where you get the company to be bound by a high risk, so you need to get the board of directors to approve such transactions. All right? All right, so we are very clear about actual authority and apparent authority. Are we good? All right, great. So let's move on. All right? So here, actual authority can come from the provision of the Corporations Act or the company's constitution. So the company's constitution can also give authority. Sometimes you have the constitution which says directors can enter into a contract up to a maximum value of $10,000. So it has been expressly given, or the powers have been expressly given to the directors to enter into such a transaction. So this is what we can look at. Or alternatively, we can also look at delegation of powers by the board to the directors. Now, what are the sections or the replaceable rules that you can recall? Who manages the company? Which section tells us that? Assuming this company adopts replaceable rules. Section 198A. Now, the board of directors may assign or delegate their powers to the managing director. Which section tells us that? Section 198C. These are replaceable rules, and they can be changed by the company if they adopted their own constitution. Now, we're talking about the next one we're looking at is actual implied authority. So here you have got managing director who has powers which are customarily associated with him holding that position. Let's look at the case of Helly Hutchinson. Now, what happened in this case was that there was a director named Richard, and he was in the habit of making decisions on behalf of the company, and then subsequently he'll inform the board. And the board was okay with this. They never actually reprimanded him for making such or taking such actions. And what happened was that Braehead Limited was a company that was going to take over another company. And the directors of that company one of them was Lord Swerdale, all right? The company they were taking over was called Purdue Limited. Now, what happened was that that company was having financial difficulties, and Richard then told Lord Swerdale, why don't you inject some money into this company, and once we take over the company, if you suffer any monetary loss, we will indemnify you, which means we'll compensate you, or the company will compensate you. So Lord Swerdale followed that. He injected some money. Later on, this company was taken over by Braehead Limited. Unfortunately, Purdue did not make any profits later on. It went into further difficulties. And Lord Swerdale, who was appointed as a member of the board, resigned, and he decided to sue to get his money back. So the question before the court was that, was Braehead Limited bound by the promise that was made by Richard? That was the question before the court. What do you think? Yes? Why? The company seems to think that he did not have authority. They said, no, we didn't give him the power to go and negotiate on our behalf, so we didn't give him the authority. That's what the company was saying. However, the court said, look, you are in a habit of allowing him to do that, and never once have you reprimanded him or stopped him from doing that. Therefore, you have allowed him or made him represent the company, and therefore, in this case, you will be bound by the decision that was made by Richard. Is that a fair decision? Yes, I think so too. All right? So, next, managing director derives authority from the chief executive. Now, here we are looking at two ways of having powers given to you. One is the provision of the Corporations Act. We can look at section 198A or 198C. Then we look at the delegation, 198A. When we look at delegation of powers, we look at 198C, where the board has delegated the powers to the managing director. All right. Now, let's look at another case. Now, this is another interesting case. It's a New Zealand case. Green and another, and Meltzer and another. Now, what happened in this case was that there was a group of companies, and the CEO of the holding company had actually thought that the company was going through some difficulties and needed a temporary loan. So they got a temporary loan from Green, an employee, and in return they mortgaged, or they pledged as security, 2 properties belonging to the subsidiary companies. Now, one of the mortgage was well well finalized and it was in the records of the company, whereas the second mortgage was not reflected in the records of the company. Now, subsequently, they took a bank loan, and when they went through difficulties, the bank actually appointed receivers and managers to actually liquidate the property and take back their money. So the question before the court was that, was the second mortgage recognized, or should the second mortgage be recognized? That was the question before the court. Now, in this case, the issue was to consider whether did the CEO have the power to enter into a contract where he could get a loan of 100,000. Did he have this implied authority? That was the question. And the Court of Appeal in New Zealand held that in such instances, it would be considered as the CEO and chairman of a holding company, which was also a public listed company, one would assume that he would have implied authority to enter into such contracts for about 100,000. Now, if he had entered into a contract worth $9 million, that would be another question. In that instance, he may not have the authority. But on the facts of this particular question, the court said, yes, he did have implied authority to enter into a contract of loan for about 100,000. Okay? Are we good? Yes. Do that, or do this, or do that. Okay? Do something. That means I don't know. I'm not sure. All right? Okay. All right, so here we've discussed this. So did the CEO of public listed company have actual implied authority to enter into contract of borrowing of 100,000? The courts held yes, but not if the borrowing was for $9 million. Right. Now we're looking at, before we carry on, what about implied authority of company secretaries? What is the implied authority of a company secretary?
Yeah, I was going to say, they can sign the
Okay. Now, what is the job of a company secretary? Very good. To comply with the Corporations Act, ensure that all the documents relevant to the company is being lodged. So this would be an administrative position, wouldn't it? Now, in assuming we have now a company secretary who has entered into a contract to purchase cars for the company. Now, is this customary of a company secretary's job? Is it or not? You don't think so? Let's change the situation. What if the company secretary purchased stationery? Is this customary of his position? Yes, it is. So that's very clear. The case you should look at is Panorama Developments Guildford Limited and Fidelis Furnishing Fabrics Limited. All right? And in this case, he actually entered into a contract to hire cars, and the court said this was not customary of his position, and therefore there was no implied authority, and the company was not bound by that transaction.
But doesn't the same concept apply that something does something outside of its object course that it's liable? So wouldn't the same thing apply there?
Very good question. Now, how do we apply that? No, I'm trying to get you to think. Now, when we say authority, I'm saying in relation to the company. The perspective we are looking at is, has the company authorized that person? Now, if you're a third party and you're looking inside, and you're saying, look, I don't care, as far as I'm concerned, this contract has been entered into, and I would assume you had the authority because you gave me that representation, and therefore this is binding. So it depends on which party you are actually advising in the exam. So you have to be very careful. If you're advising a third party, you would say, yes, this applies, regardless.
So it's not, if I sell something to a company, it's not my fault that the person buying from me is not authorized to buy, right? You want the company's behalf.
Yeah, provided that you have the right to assume and you have not lost the right, they would be bound by it. Not a problem. But what would happen to the directors would that be is that under Section 140, they would have breached their duties, and then the company can instate an action against the directors. So that's a separate issue.
The company would still be bound by it.
Yes, they would still be bound by the contract. All right? So let's now look at apparent or ostensible authority. Now, this apparent authority, as I told you, is on the perspective of the third party, the outsider. All right? The third party looking inside and think, does this person have authority? So the first thing that you need to establish is first, that the principal is holding out. Second, it was made by the principal who has authority to make such representation. And third, outsider relies on the principal's representation. Now, I'll give you a scenario. Assuming you were a partner in Deloitte, all right, and you had your name on the letterhead, all right, you subsequently resigned and you started your own partnership. Okay, you started your own accounting practice. But Deloitte, for some reason, did not remove your name from the letterhead. So you're now going on to negotiate contracts, and you actually bring this letterhead with you, and you show them, look, I'm a partner with Deloitte. Why don't you sign up a contract with me? And then later on, the third party realizes that you are no longer with Deloitte. Now the question is Deloitte bound by the contract that you have entered into? Why? Yes, why? No, why? No? Why not?
Because if I have my name on Deloitte's letterhead, it's my fiduciary duty to not misuse it.
We don't care about your duty. We care about the third party now. We are looking at the third party's perspective. What will he would have thought? Who's making the representation? Deloitte, because it's Deloitte's letterhead. So there is a principal. Does Deloitte have the authority to make that representation? Yes, so that's holding out. Did the third party rely on that representation? They obviously did. So as far as the third party is concerned, there is apparent authority. That's it. All right, so what's the moral of the story? Quickly remove it from the stationery. Okay, that's why you see most agents, like if you have salesmen working for you in a company, the minute you resign, they actually take up an advertisement and say, this person is no longer working with us. Right? They're actually informing the world that this person is no longer our agent. They are taking precautionary methods or steps to prevent further complications, if any. Okay? And the case we actually look at for this situation would be the case of Freeman and Lockyer and Buckhurst Park Properties. Now, this is for the first requirement, i.e. principal holds out or makes representation that agent has authority. So in relation to that principle, we are now looking at the case of Freeman and Lockyer. Now, what happened in Freeman and Lockyer is that Mr. Kapoor is one of the directors of the company, and he is also in the business of making decisions on behalf of the company, which the other directors didn't quite bother so much. They were in the property development business, so what he did was that he hired two architects to actually develop a property before trying to sell it off. Now, these architects believed that he had the authority, just did the job, and finally when they gave their fees or the bill for their fees to be paid, the company refused to pay their fees. So the question now before the court was the company bound by the transaction that was entered into by Mr. Kapoor? That was the question before the court. What do you think? Yes, why? Always learn to answer why. Because in the exams, you can't just put yes. You need to substantiate why. Okay, how did the company make the representation? Okay, right. He's acted as if he was the managing director, although he was not officially appointed. All right, so that gave an holding out. So the principal was holding out that he was a sort of a managing director because they never kind of questioned his decisions. And did the principal have authority to make such a representation? Yes. Did the architects rely on the representation? Yes, they did. So in this case, the court said, yes, there is apparent authority, and therefore the company is bound by the contract. Now, the reason why are we not using actual implied authority? Sorry? It wasn't given? How is it given? You appoint him as the managing director. So in this case, sorry? Yeah, you appoint him. So in this case, they did not appoint him officially as a managing director. So that's why we can't say that is customary of his position. It's not customary because he's not in that position. Okay? All right. Now let's look at representations for apparent authority. An agent with apparent authority cannot confer apparent authority to another. So if you yourself are a person on apparent authority, you can't then confer authority to another person. The case that you'd cite for this would be Crabtree Vickers, Proprietary Limited, and Australian Direct Mail. And a de facto means a director who's not been appointed officially but by fact acts as a managing director can make representations, and the case you can look at is Brick and Pipes case. And the last situation is holding out can occur by equipping the officer with the title and facilities of Pacific Careers Limited and BNP Paribas. Now what happened in this case was that there was an agent who actually authorized for a ship to make some claims if they went into some problems. Now this party who gave the authority was a credit control person who's not actually authorized to give such approvals. However, she did give the approval, and the ship owners came and made a claim. So the question was whether or not the bank in this case has held out this agent as having authority to act on their behalf. Now, when they went to court, the bank argued, look, we did not hold out that she had authority. She herself showed to the third party that she had authority, and therefore we should not be bound by it. However, the courts disagreed on this, and they said that since the bank equipped the staff with the title, the status, and the facilities, and they also did not establish proper safeguards, therefore they would be bound, or they would be said to have held her out to have authority, and they will be bound by the contract. All right, so this was what was held in the case of Pacific Careers Limited and BNP Paribas. Okay, I know it's a bit too much for you to take, but in good time you'd get it. Okay? All right. So we have looked at how a company enters into a transaction. We have looked at directly and we have looked at indirectly. Directly, we said that first the company has to have authority by the passing of the directors' resolutions, first authorizing the transaction, second authorizing the persons to enter into the transaction. Next, we looked whether the company adopted the common seal or did not adopt the common seal. If it adopted the common seal, we looked at section 127 sub 1, adopted the common seal section 127 sub 2, where two directors or one director and a company secretary will witness the affixation of the common seal. Under section 127 sub 1, where the common seal is not adopted, then two directors or one director and one company secretary will execute the document. Then we looked at indirectly. Under section 126, we said companies can enter into a contract indirectly through the use of agents. Now, when we have the law of agency, we have to see what is the authority given to them. One, it could be actual authority. The other is apparent authority. When it comes to actual, we looked at express and implied. Express is okay, it's by words, by conduct, whichever way that is expressly perceived. It could be via the Constitution, via the Corporations Act, or even delegation of powers. Now, when we come to implied, we looked at positions which have got customary duties related to the position. So we looked at situations when it would be customarily deemed to be implied. Then we looked at apparent authority. We looked at 3 requirements. The first is there is a holding out by the principal. The second, the principal has authority. Third, there is reliance by a third party. If you can establish this, then the company will be deemed to have given apparent authority, and therefore they will be bound by the transaction. All right? So we've looked at that. Now what we're going to move on to is we're going to move on to enforcing defective contracts made by agents. So now you have got some contracts been made and they have exceeded their authority, so this becomes a defective contract. Now what happens to the third party? What can the third party do? That is what we are going to look at. All right? Defective contracts will be where a contract is entered without authority or where there is some procedural failure known as defective contract. So the law tries to balance the interest between the company and the third party. So they try to protect both the company and the third party. They're trying to get some balance between these two parties. Now, where the agent has not acted within the authority or has not followed approval procedures, there is no way for outsiders to know of this irregularity. Let's just give an example. Assuming you've got a letter from Harvard saying you've got full scholarship to go and do your master's there, what would the first assumption be for you?
Absolutely.
Assuming you have applied for Harvard, obviously. If you didn't apply for Harvard and you got some scholarship, there must be something wrong. All right, so now you've applied and you've got a letter saying you've been accepted, you've got full scholarship, stipend and all that. For the next 4 years, you will be in this graduate school doing your MBA. And after that, you've got also assurance that you'll get a job in Harvard. What would you think?
Actually, at first I'll be very happy, but then I think twice. I'll be like, hold on, what are they not saying?
Oh,
That sounds too good to be true. Like, are you sure?
sounds too good to be true?
I don't know.
Okay, I'll be jubilated. I'll buy a ticket and I'll be on my way. Okay? Now, if I bought a ticket and then suddenly Harvard sends me a letter, excuse me, I'm sorry. Actually, the person who signed that letter was not authorized to sign the letter, therefore you did not actually get the scholarship. Huh. What would you do? Go back? Would you do that? Or would you say, I don't care whether who signed it or not, I got the letter, I'm going? Would you say that?
I would do that, but also proof. Like I'd have something else up my sleeve in case, you know.
So how many of, okay, let's not use Harvard then. Let's use some other example. Assuming you have now gone into a mall, or let's not use a mall. Let's use a small business. You've gone into the shop and you see products there. Okay? And you want to buy the products. Do you assume the products were stolen? No. You would assume, sometimes. Oh my God. So here, what you are concerned about is that the products there are available and they're legally made available. So that's what you would think, right? You wouldn't know whether they're actually stolen goods or whatever, right? So if you knew it was stolen goods, obviously you're dealing with stolen goods, then that's a problem. Okay, so what I'm trying to state here is that it is difficult for the outsider to determine whether or not the internal happenings of a company has been complied with, because we are outside, we do not know, right? Even you wouldn't know whether my employment with Curtin has been regular. Have I actually signed the dotted lines? You wouldn't know. All right? So you have the right to assume that everything that has happened has been done in a regular manner. Now, if you have a bank and it's going to approve the loan that you're going to apply, and you have actually supplied all the resolutions, you have supplied all the documents, would the banker then want to ask you, is this original document, are you actually authorized? Do you want them to ask that? They probably have no time because they have a lot of documents to go through. So they would have the right to assume that everything that you have supplied is the original and the right document. They wouldn't know whether the resolution was actually signed by the directors that has been mentioned. All right? This is to enable business transactions to move on seamlessly. Otherwise, everyone would be doubtful, everyone would be second-guessing every document that they receive. All right? So that's why we have got this rule which says the right to assume, or we call it the indoor management rule. So the common law recognizes indoor management rule, and this has been codified under the Corporations Act, which now we know it as statutory assumptions found under Section 128 and Sections 129. We'll look at that now. Yes. Well, if there is a mistake internally, that's not the problem of the third party, because they have the right to assume that all documents furnished was original and was validly passed. So they have the right to assume.
So it happened with me, like, for example, using Harvard, correct claiming and actually stayed there.
All right. As long as you have supplied the document, the third party will say, we have the right to assume. But if you have breached something internally, that will be something the company will deal with you. All right? Now, let's look at the indoor management rule, which actually started with the case of, or which was decided in the case of Royal British Bank and Turquoise. Now, in this case, there was a loan of £2,000 that was taken, but it was signed by 2 directors or passed a resolution, but this was not authorized by the board of directors. Subsequently, the company went into liquidation, and when the bank was trying to enforce to get the amount paid back, the company then said, look, we did not authorize these 2 directors to sign the resolution and to actually get the loan. So, therefore, we are not bound by this transaction. All right? So now this is the liquidator or the trustee in bankruptcy who's trying to get the money or recover the money for the creditor. And the bank said, we did not authorize and it was not done regularly, therefore we are not bound. Now, when it went to court, the court said, look, whatever irregularity that's happened within the company, it's the company's problem. As far as the third party is concerned, as long as the documents satisfy the requirements, they will assume that it has been properly passed. Whether it's been passed by the full board or not, that's not their problem. They have the right to assume. However, there is a caveat. This right to assume will be lost if you had noticed that the document was not the proper document, or you were put into inquiry. Now, common law says put into inquiry. Let's now illustrate that. Assuming many years from now you're married and you have, obviously, assuming your partner, I don't want to specify the gender, and what happens is that you want to take a mortgage, a second mortgage on your house. So you actually pay your partner to go on a holiday. Say, honey, go for a holiday. I'm sponsoring you. You need a break. All right? And then the bankers come in to make an inspection of the property. And they actually see a cupboard filled with a woman's clothes, for an instance. All right? Now, if you were a reasonable banker, what would you do? Try on the clothes? Now, what would a reasonable banker do if they found a cupboard filled with female clothes and they are dealing with a male customer or client?
Are you talking professional?
Yeah, and professionally as a banker. You mean you have some unprofessional? Okay.
Look, if I was a banker, I'd be thinking.
He gender bends and he changes. Okay, now you all are very good bankers. Now, a reasonable banker would then ask, are there anyone else who's got an interest in this property? Whose clothes are these? Why are they there? Because a reasonable banker would try to establish whether or not the property belongs to a single person or whether there are 2 persons who own the property. All right, so Now, I'm giving an example. I mean, obviously, I hope they don't open the cupboard, but okay, just imagine they don't open the cupboard. They see shoes, female shoes, all over the house. Okay. Probably, but how would you know if you don't ask? You're put into inquiry, aren't you? Yeah. So the minute you're put into inquiry, you have to ask. And if you do not ask, when a reasonable banker would have, you would lose the right to assume under the common law. All right? You will lose the right to assume either when you know or you're put into inquiry and you don't question about it. You will lose the right to assume. Okay? We'll look at section 128 sub 4, which is quite different from the common law because it is much more narrower. What section 128 sub 4 tells us is that either you know or you suspect that it is incorrect. Now, suspicion is subjective, whether or not you yourself have some suspicion. But when you look at the common law does not have subjectivity, it has objectivity. It bases on objective assessment. Would a reasonable person be put into inquiry? So if you see the statute and the common law, they are a little bit different. The common law is much more stricter compared to the section. Okay, are we good? Right, I hope so. Now, the exceptions is outsider has actual knowledge or ought to have known since they were put into inquiry. Now, this is the case that when you talk about defective contracts, which has been assessed in the final exams. So when you talk about defective contracts, you talk about the common law position first. You establish the general rule in Turquoine's case, you explain what it is, and then you have to look at the exception. When the third party ought to know or has been put into inquiry. When you're discussing when put to inquiry, you actually look at the case of Northside Developments Proprietary Limited and Registrar General. Now, what happened in this case was that Sturgis was one of the directors of Northside who actually irregularly used the company's land to secure borrowing. What he did was that they passed a resolution saying that they want to loan money, and they used the company's major asset as security for that particular loan. He actually has got his son to act as a company secretary, although he was not officially appointed as a company secretary. So they passed that resolution, they put the property belonging to the company as a security, and the best part of this transaction was that the money was to be deposited into another company which had no relationship with Northside Development. Now, if you were a reasonable banker, would you have thought that is peculiar? Would you? You are taking a major loan against your major asset, but the money is not coming to your company, it's going to a third-party company which is completely unrelated to you. Isn't that weird?
Yes.
So in this case, the court said, since it is not something that is normal, it's out of the ordinary, why would a company take high risks by pledging in their assets and taking a big loan when they're not going to get the benefit of the loan and someone else which is not related to the company is going to get the loan? In this case, the court said the banks were put into inquiry, and since they did not or they failed to inquire, they cannot have the right to assume. All right, so they've lost the right to assume in this case. So was Northside bound by the loan? The court said no, they were not bound by the loan. Now, Barclays Bank could not rely on Turquoine's case. The bank should have suspected, since the loan was outside company's usual business and charged company's major asset. Now, this will be contrasted with the case of Story and Advance Bank of Australia Limited. Here you have Mr. and Mrs. Story, who were directors of the company of Fleetwood Star Proprietary Limited. Mr. Story decided to take a loan of $1 million, and he decided to forge Mrs. Story's signature and got the loan. The purpose of the loan was half of it was to be used for the company, the other half was to be used for own household expenses. Now the question before the court, is Fleetwood Star Proprietary Limited bound by this contract? Or does the bank lose the right to assume? What if the bank has actually asked Mr. Story, what are you going to use this money for? What do you think would the answer be? For the business, because some part of the money is still going into the business. So he would have answered, yes, well, I'm going to use the money for the business. So in this case, you can distinguish not side, because the risk is taken and some benefit is still used on behalf of the company. Therefore, the banks did not lose the right to assume, and Fleetwood Proprietary Limited was bound by that contract. Get it? Not side, the benefit was not for the company, it was for someone, some other company which is totally not related to not side. But in this case of Fleetwood, there is some benefit the company is still getting. Therefore, in this case, there is still right to assume. Okay? So this is the distinguishing case. Then we look at statutory assumptions. Section 128 sub 1 tells you situations when the courts can assume. And these are the situations. Under section 129 sub 1, when you deal with constitution and replaceable rules, the third party has the right to assume that these have been complied with. That means you have complied with the replaceable rules, you have complied with the constitution. They're not going to ask you, have you complied with the constitution? All right? They're not going to do that. 129 sub 2, directors or company secretaries named in public documents has been duly appointed or has the customary power of that position. So again, they're not going to tell you or ask you, a third party can just assume that you have been appointed. If you presented yourself as the director of the company, they will assume, yes, you have been properly appointed. If you say you are the company secretary, they'll assume you have been properly appointed as the company secretary. You have the right to assume. Under section 129 sub 3, anyone held out to be the officer or agent of the company has been duly appointed and has the customary power of that position. Now, fortunately or unfortunately, section 129 sub 1s, 2, 3 and 4, 5, 6 will be examined, because when it comes in the examination, you will have one of these situations and you have to know which subsection applies to that situation. So please have it in your cheat sheet for your final exams. Now, individual directors, normally no customary authority unless actual express authority given or director was held out. Please note there is a difference between a managing director and individual director. Just a director in a company does not have any customary duties or customary duties in relation to his position, because he's just a regular director. He just comes to decide in the board of director. But when you're a managing director, you have got the customary duties because you run the day-to-day management of the company. Now, managing director, customary authority to manage, i.e. to employ staff, borrow money, and we have seen this in Freeman and Lockyer. The chairperson, again, same customary authority as individual director. So here, they do not have any customary duties associated to them. Secretary, I have already discussed just now, they are administrative in nature. So if you do anything that is non-administrative, again, you would not have the authority to do so. Now, the limitations to assumptions and the effect of fraud or forgery, let's look at section 128 sub 4. As I was telling you, if you have noticed or you knew about the information not being true, or you have reasonable reason to suspect, again it is subjective, then you will lose the right to assume. All right? Under statute, you lose the right to assume under section 128 sub 4 if you knew about it or you suspect that the information is incorrect due to some given reasons. Under the common law, you will lose the right to assume if you knew or you were put into inquiry and you failed to inquire. All right, so the common law and the statute is a little bit distinctive. However, both areas of law will apply. All right, so we have common law as well as statute applying. Under section 128 sub 3, what if you had forgery? there is an assumption under Section 129. It can be made even if the officers or agents have forged the documents. Unless this was made known, they have the right to assume that it was properly signed. All right, so they will not bother about forgery. Now, again, Section 129 sub 5 allows an outsider to assume that a company document has been validly executed if it's without seal under Section 127 sub 1, and if it's with seal, Section 127 sub 2. Section 129 sub 6 allows outsider to assume that the common seal has been affixed properly. These assumptions can be made even if the person signing or witnessing have not been duly appointed. So these are the various sections. So again, in summary, when we look at defective contracts, we are actually looking at the common law position of the right to assume under Turkwan's case, and we are looking at sections 128 and 129 under Corporations Act. So when we look at Turkwan's case, we say that the third party has the right to assume, and this right will be lost if they actually knew or were put into inquiry. Under Section 128 sub 1, it says you have the right to assume under Sections 129 sub 1 right up to sub 6. Any of those sections, you have the right to assume. However, you will lose the right to assume under Section 128 sub 4 if you knew that it was incorrect, or you have suspicion that it was incorrect, then you will lose the right to assume. Under Section 128 sub 3, even if there is forgery involved, so long you are not aware of it, you still have the right to assume that it has been duly executed. All right? So this is what we have looked at in terms of contract. We looked at how the company enters into a contract, and we looked at what happens when there is a defective contract. Now we are moving on to corporate liability. Now, corporate liability is not something that has been examined in the past, so you have to concentrate on contract. That will be highly examinable. But let's look at, will a company be found liable for torts and criminal actions? Yes, they can be found liable for torts and criminal actions, either directly or indirectly. If it's directly, it depends whose mind do we take into account? Whose actions do we take into account? We take into account the board of directors or the persons who are in the controlling position. So the controllers of the company would be the board of directors. If they make a decision to do something that is wrong, then the company is said to have done that wrong. All right? The other way that the company may have liability is called vicarious liability. Now, vicarious liability is where the company is liable for the action of its employees. For an instance, you were happily walking after class, and the floors were slippery, you fell down, injured yourself, now you have got casts on both your hands. You obviously don't want to sue the cleaner because they don't have much money, but there has been some tort there because there's negligence. What do? You sue the cleaner and you sue Curtin. I didn't say that, okay? But anyway, that's what you do. So Curtin will be vicariously liable for the action of its employee. All right? Now, in Lennart's Carrying Company and Asiatic, what happened was that Lennart was the owner and the manager of a company which actually manages ships. And he actually had a ship which was not seaworthy. The boilers were actually spoiled. But nevertheless, he allowed that particular ship to go to carry some cargo. In this case was benzene was carried in cargo. But the ship went aground. And of course, the person who used that ship to transport their cargo were now making a claim for the loss that they have suffered. So the question was whether or not the company was bound by this particular loss. Now, in this case, they said Mr. Lennart's state of mind is the state of mind of the company because he was the controlling managing director of the company, and therefore, since he had knowledge that the boilers were not functioning properly and the ship was not seaworthy, and despite that information, he has allowed the ship to take the cargo. Therefore, in this case, the company will be found liable. All right? Are we good? All right. Now, who is the directing mind and will of the company has been explained by Lord Dennings in the case of H.L. Bolton Company Limited and T.J. Graham and Sons. He said the persons who manage the company are the people on the top. So your regular clerks, your regular managers who do not have much authority to make any changes in the company will not be the directing mind and will of the company. The directing mind and will of the company will be someone on top. That's managing directors, board of directors. These are the people who be considered as the brain of the company. All right? Now, in the case of Tesco Supermarkets Limited and Natras, what happened was that they have, Tesco's always have sales. Tesco's is a regular, like Woolies in England, okay? So you just go there and you buy and you have a lot of specials. So they had specials for detergents, all right? And subsequently, the specials ran off, but then they had the special prices still on the display. Now, one of the ladies went to buy the detergent, and she said, look, I have the special price, I want that price. And obviously they said, no, that time has gone, it's now back to regular price. Now, they were found to be liable, or an action was taken for under the Trade Practices Act, because saying that they were misleading and being into deceptive conduct against customers. And the question before the court was, whose state of mind was relevant? Was it the manager who runs the Tesco's day-to-day management, or was it Tesco's board of directors' mind? Who was negligent in this case?
Are we talking business level or corporate level?
Corporate level would be business level as well, right?
I would say, women say board.
Yeah, I mean, an average manager in a store would not be able to hire and fire people. All right? So he wouldn't be able to do a lot of things. He can't just decide, oh, we'll just discontinue this product. He can't decide all that. Who makes that decision? The directors at the top. So in this case, they said by the fact that they did not change the pricing, it was not the directors who actually did that, and therefore the state of mind of the manager here, who is at the lower rung, was not the state of mind of Tesco. Okay? All right? But however, we have got a different decision in the case of ABC Development Learning Centre Proprietary Limited and Wallace. Now, what happened in this case was there was a childcare centre and they were negligent because the carers were not careful, as a result of which a child escaped. And the question was whether or not this ABC Development Learning Centre Proprietary Limited was liable for the negligence of the staff. What do you think? Who's the directing mind and will of the company? Sorry? Low level? Yes, in this case it was low level. However, they did still find the company liable, saying because the intent and purposes of the act was to protect children, and generally taking into account that they were dealing with younger children, they held both the company and the staff to be liable for this action. All right, so this is a contrast case from what we looked at Tesco and Natras. Right, so today, as we go back, you have to know how a company enters into a contract, directly, indirectly. How do you deal with defective contracts? And last but not least, corporate liability, which you can just know it for the information purposes. I hope you have a good day, and those of you who have not done your test, good luck.
Sorry for being unprofessional.
Oh, no worries.
Yeah, look, if I was a banker, I would not even go